Hello and welcome. We're talking tonight about a very big topic that affects all of us. We're talking about divorce and about navigating the waters of divorce. The statistics that we read vary somewhat, but approximately 50% of all marriages end in divorce. And so it behooves us to know as much as we can about the process, about how to make it smoother. And with me tonight is a guest who's been on before. Charles Goldstein is back. He's a divorce and family lawyer from the western suburbs, and
right.
Welcome back.
Thank you.
Well, divorce has changed a lot from the time I was divorced way back. And now we've got arbitration, we've got mediation, collaboration.
Correct.
Tell us a little bit about each of those options as opposed to just strict divorce as probably I went through it, Charles.
Okay. People frequently confuse the terminology: mediation, arbitration, collaboration. Arbitration involves a decision maker, an arbitrator. That is
outside person.
Right, a neutral, of course. Mm-hmm. It may be a family law attorney. It may be a retired judge who now decides that they'd like to hear cases more informally in a conference room of an attorney rather than in a formal courtroom. Very few people opt for that process, but in almost any case, a judge would approve an outside force, such as a retired judge or a family law attorney, hearing all the facts in the case, still having evidence exchanged, hearing testimony, hearing witnesses, but not in the formal setting of a courtroom. Their decision can be deemed non-appealable, which is another benefit to doing arbitration, so that neither party has to be concerned that the decision will be overturned at a lot more additional expense after a trial would be over.
So would it prove to be less confrontational, usually?
Well, there'd be less angst in the parties if they're not in a formal courtroom in most cases.
Right.
At the same time, it's a more comfortable atmosphere for them to have their matter aired and present evidence when no member of the public can come in to observe what's going on, because any divorce trial, any divorce hearing is open to the public. And so this way, it's a way of keeping your matter private and still having all the evidence on the table and still having any irrelevant evidence kept out of consideration and reaching a conclusion. There's some cost involved. An arbitrator might cost $200 or $300 an hour or more, but you don't have to go through several hearings prior, which we call pre-trials. And so by and large, people will save a lot of money if they have their case arbitrated. But we're finding very few people are willing to have the matter heard by a non-judge because they believe that a judge has a special qualification to decide their family situation that a family lawyer wouldn't. And I don't know if that's the case.
So it's not as common as perhaps mediation?
Right, mediation is much more common.
Tell us how you define mediation.
Mediation is defined as parties and their attorneys, or parties without their attorneys, getting together with a mediator. Now, a person may feel uncomfortable not having their attorney present at mediation, and if one person wants their attorney there, both attorneys have to be there representing the parties, because no competent mediator will allow there to be a mediation with only one party represented. A mediation involves sitting down with a person designated as mediator. Again, it could be a family law attorney, it could be a retired judge. Those are your two best options. And that person is normally paid out of the marital funds or paid by each of the parties out of their own separate accounts. The mediator will hear each of the people's needs and concerns and try to avoid having positions be polarized and making a decision on the case for the parties when they can facilitate conversation instead and help the parties have discussions so that they can reach their own conclusions about their future. As many judges will tell you, if a matter is heard by the judge can learn very little about the family and the amount of time that a court can take to allocate to a family having their matter heard. A mediator might take 2 or 3 hours just to become familiar with the parties, familiar with the facts, and hear angles that can be pursued without the necessity of any sort of trial atmosphere. Some people give the example, a mediation can work as it would if people were arguing over an orange, and one person in reality wants the peel and the other person wants the juice. And if someone didn't ask enough questions to figure that out, they may be arguing over this orange until the orange is completely destroyed and no one gets an orange.
That's a good analogy. And then a collaborative kind of process. How does that differ?
Collaboration is yet another manner in which we resolve divorces. In collaboration, each person has an attorney present throughout the matter. We sit around a conference table, we talk through the issues, we brainstorm, look for common goals and ideas that people have, and the case evolves in such a way that both parties are feeling more in control than they would in court or even with a mediator. They're able to talk through any number of issues that even a court may not be able to address under law, reach all kinds of agreements, and avoid any of the behind-the-scenes work that goes on in a divorce. For example,
So would that be the most informal, Charlie, of the three?
right.
The collaborative process, okay.
And we generally avoid writing letters, making motions, or even telephone calls. We try to have all meetings happen in person so everyone feels that they're part of the process, they're part of the result of the process, and they don't feel as if things are taking place behind their backs. And letters aren't being written that misconstrue points of view or that are misinterpreted. And we don't have the lengthy delays that are caused by you telling me ABC is your attorney, then I tell the other attorney ABC, and by the time it gets to their client, it's XYZ. We do the round robin.
Like telephone,
Right.
the old telephone game.
Right.
Which of the three do you prefer using when you're working with a couple?
It really has to be designed by the case. So for example, if a couple is arguing over how to divide personal property, they're by and large almost always going to be better off with the help of a mediator, because a mediator is one professional that you're paying rather than two lawyers. Two people can go to a mediator and work through all of the personal property, the pianos, the television sets, and all the masses of property people tend to gather nowadays that needs to be sorted through, and have the mediator assist in how to divide the property up. There's no legal issue generally involved in division of personal property. If there's a major legal issue about a non-marital claim, for example, someone claims that the grand piano was a gift or was inherited from grandmother, that might be a legal issue. But even those can be handled through a mediator without attorneys present. If the attorneys are involved, we can save the cost of the third-party mediator by having the attorney sitting down with the clients collaboratively and working through the case, just paying two professionals to help resolve it. And people have that buffer of their own attorney present, they can feel less insecure in the process.
Well, they all are interesting and all have some pros and cons, don't they? Prenuptial agreements are, it seems to me, getting much more common. Am I right in assuming that or understanding that?
They're more common than they used to be, but judging by the cases that I see come through as divorces, they're still quite uncommon. So in each divorce that comes to my office, maybe 1 out of 10 have a prenuptial agreement in place.
So not a big percent at all.
Right. Very few people think of a prenuptial agreement before getting married.
Do you think it's a good idea?
There really is no downside to it, Mary, other than if it causes an unforeseen argument.
I think it's a threatening thing for people sometimes.
And it's wise to even see a counselor about it beforehand if you're trying to work through it in a way that doesn't do any harm to the relationship before the marriage. So
why would you want a prenuptial? Don't you think we're going to stay married?
Right,
you
that
know,
would be the common response to the person on the receiving end.
Common. But some real pros when you get to the divorce, if that happens, right?
People could wind up spending $20,000 or $30,000 on an accountant to prove that the assets they originally held are still non-marital in nature. In other words, don't belong in the marital balance sheet because the stocks they owned at the time of the marriage are still the same entity, or their company is the same entity, or a piece of real estate is still the same value. And if we can stipulate, in other words, agree to these things in a prenuptial agreement, and everyone knows what they're getting into, and it's fair and it's conscionable and it's procedurally correct, then a lot of proof issues go away at the time of the divorce. And we're not going to a trial or a mediator or through collaboration to determine what is staying off the marital balance sheet, and people have more predictability in what will occur if there is a divorce, and they can provide for that by having that agreement in place.
So it's really probably a very good thing to do.
Right, I can't think of any downside to it.
When a couple is going through a divorce and have children, I think one of the hardest parts is the custody of the children issue. It seems to me that more and more couples are having joint custody as the plan. Is that true?
That is true. Joint custody is becoming a more commonly used label. Now the courts and the legislature have taken a lot of the power out of the terminology. In other words, we used to have a lot of trials over custody. And the trial system and the legislature recognized this was tearing up a lot of families. People were looking for what they could throw at each other to try to become the legal custodian or physical custodian. And judges would be faced with contrary versions of what a family was all about, because the wife had one version, the husband had another completely different version. And judges would throw their hands up and say, if I believed all this, I'd take the kids away from both of you. And so instead, what they have done is taken the power out of those terms. We now determine child support based on parenting time. So if where the children are not primarily residing is with mother or with father, we look to that person's percentage of overnights generally. And if they're between 10 and 45%, there's a parenting time credit that person receives toward their child support. In other words, they pay less child support. If they're seeing the children less than 10%, there is no credit. If it's more than 45%, it's an even greater credit. So we look at what people's schedules are. What are their work schedules? What's best for the children? What are the ages of the children? Then we can gauge what is the most appropriate parenting schedule. And ideally, you'll have a child specialist enter the scene as a neutral, work with the people and figure out what is the right schedule as opposed to label for the custody.
So if a couple is having joint custody, it doesn't necessarily mean that they're going to split the costs equally. It depends on the income of each person, correct?
Right. We look at the gross incomes for each of the parties. We used to mess around with net incomes. The legislature did away with that back in 2008. So we don't look at retirement deductions. We don't look at a number of other deductions because that created so much more work for the attorneys and the courts. And so now instead, anyone can go on the Department of Health child support calculator, plug in gross incomes and some other factors, and come up with what the child support will be, so long as they know the number of overnights that the non-custodial parent will have. And what
So it's pretty cut and dried then.
It's fairly cut and dried, much more so than what it used to be in past days.
And does it usually, Charles, extend until age 18 or through college? What's the latest?
It's until age 18 or graduation from high school, whichever occurs later. Now, it can go until age 20 if the child is still attending secondary school. So if a child hasn't graduated high school, for whatever reason, then child support remains payable until the child reaches age 20, unless they suffer some sort of handicap that makes them unable to be self-supporting. But if the child has a job at age 20, it's definitely going to end at that point. And there's some cases where parents are arguing in court or through lawyers as to whether the child should have graduated, and whether the substitute diploma they received is or is not a valid graduation date for purpose of any child support.
I can imagine that could become a sticky issue in some families.
It'd be a sad one.
But college, it's up for grabs in terms of the responsibility of which parent, the child, etc.
As far as the law is concerned, now people can agree that there will be child support payable until children are an older age, until they finish college.
That's something that could be brought up at the time of the mediation or the collaborative process, right?
And if there's an agreement for more payments to be received beyond that date, then the courts will enforce agreements people make to pay support over and above the statutory date for child support.
Are there reasons that are subtle that we wouldn't think about why having joint custody would not be a good idea? I mean, of course, if there's an abusive parent or history of alcoholism or drug abuse, those things we get. But are there some other things that would make you as an attorney advise against joint custody?
What's important to distinguish, Mary, is legal versus physical custody. Legal custody has to do with major decisions involving medical, religion, or education. Now, in most marriages, the religious aspect and the educational aspect aren't big factors. Both parents agree they're going to have their children go to the best school that's available for what they can afford, and they agree that their religion is not going to change. Where it comes up sometimes is medical decision-making process. Now, if one of the parents does not believe in inoculations or is more holistically oriented, the other is more medically oriented, those are a bad mix to have joint legal custody. So what we sometimes do is say, let's say you can be joint legal custodians with the one exception that when it comes to a medical decision, here's how you're going to resolve it. I often suggest get a second opinion, and if the second opinion doctor disagrees with the primary doctor, then we go to a third opinion. There often isn't time, though, for those kinds of multiple opinions in the case. And in that case, we put in time constrictions. So if the parties can't reach an agreement, or if the other party can't be reached because they're in the military, or they just are poor communicators, we might say the parties will make every effort to reach an agreement within the first 3 hours of need, And if no agreement can be reached, then spouse A that has a primary custody, primary legal custody, will be the one to make the decision. So the person will make a good faith effort, but we often do this to avoid a trial as well, because again, a trial over whether parties can communicate can make it even worse for them to communicate.
Right, that could
Which would be an
really,
irony.
the anger could come up. When I was reading your website, you use some words to describe people's feelings as they are going through the divorce process. And I just thought I would read those out loud, because I thought, oh, these really hit the nail on the head in terms of what people go through. You write that often people are angry, they're often feeling confused, they're feeling tired, all kinds of feelings, that resentful, upset, stressed. All of those, I thought, yes, that's what I remember, and that's what friends who go through divorces talk about. And it makes it extra hard to have to think so clearly and over such important things, doesn't it? When your emotional life is kind of a roller coaster.
Right. The buddy system is something I recommend for that. If you can bring a friend in with you, someone you trust, not to talk about your issues obviously outside of the room, that's a great ideal
idea.
situation, because then you've got someone who can, after the meeting, go out with you for coffee and say,
Right.
let's review the notes we
Right.
took away from Mr. Goldstein and see what were the most important things to keep in mind and what were some of the answers to the most important questions, because people do come in with fuzzy heads, and when they leave, their heads can be even fuzzier because now
Right.
they've got an overlay of facts
Right.
over the emotions, and the emotions
Well,
were
that's
already in bad shape.
Excellent idea. I've not really heard that in terms of a trip to the lawyer, but we hear that going to the doctor, bring a buddy, but this is a great idea. Alimony. I don't hear people talking about alimony anymore. Is that because that's less common?
Alimony is what we used to call spousal support. Now it's referred to as spousal maintenance. For whatever reason, the legislature determined that spousal maintenance was a better term than alimony, but it's just academic. It means the exact same thing. Maintenance is less common than it used to be many years ago, because the courts have become more strict about people going back to work even after the children are just starting school. Now, what many couples are doing are reaching what are called care and waiver arrangements. And you might hear about that from friends or others getting divorced. Care and waiver means that people are agreeing not to go back to court at any point in the future to revisit a spousal maintenance arrangement. So there might be an arrangement of 4 or 5, even 10 years of spousal maintenance in which there'll be no modifications unless there's some drastic reason that comes up. Sometimes I'll say my client will waive any modification unless they lose their job due to disability or through no fault of their own. But the great thing about these kinds of arrangements is that it avoids future proceedings in court, which people are arguing about ability to earn, whether someone is making XYZ amount of money in their self-employment. And we'd have many, many hearings in the past in which there were actually trials about who was making more or less money than they had at the time of the divorce. And big use of the court's time. The court can't afford so much to hear those anymore, nor can people afford to pay lawyers to go back to court to argue multiple times. And they want some more certainty about their future, so they enter into these maintenance arrangements.
One of the things I learned in the last few years is that if you are married more than 10 years to your spouse, as a woman, you can have Social Security based on your ex-husband's earnings. And I think that's a law that is not very well understood or talked about. So I'm thinking, boy, if I have a friend who's been married 9 years and she's considering a divorce, we should advise her, stay in there 1 more year, right?
Well, not if there's domestic abuse.
Well, no.
But as a
True.
financial decision, that's correct. There's some fair certainty then that they're going to collect at a higher level of Social Security if their husband had more work years under their belt and a greater earning
I mean, it's
record.
a very individual kind of a situation in the future, but
Right, and they want to make sure to call the Social Security division to make sure that they're operating on the correct facts.
Right.
Because it's a very technical area, and they have very good help people that will answer the phone and address those
Give
questions.
you advice.
Right.
But it's hard sometimes when you're in the midst of a crisis or a divorce to think way ahead to, when you're over 65. And
Right.
So it's just an interesting mind.
Most people that come in want to be divorced yesterday.
Right.
And
Once
might
they
have
make
been-
the decision, right?
They might have been married and then separated for 20 years, but now they're in and they want to be divorced ASAP.
That's, yeah, I can
So they don't think
imagine
ahead a
that.
lot.
We're hearing a lot right now about the marriage amendment in Minnesota. As an attorney, what are some of the things that you lose out on if you are not legally married? I think we know some of them, but
Okay.
you know, people are really thinking hard about this right now.
Right. There's so many examples, Mary, of where rights are not there for same-sex couples. There is an organization called Project 515, and they list on their website 515 laws that are there to protect spouses. So if you go on their website, you can see 515 of the laws that are there to protect me as a spouse. But if I have a relationship with someone who's a man long-term, I'm not going to be able to visit him in the hospital if the hospital has restrictions that relate to family, because I'm not technically family. Now, the hospital may bend the rules, but technically speaking, the family would have the first right to make those long-term health care decisions, if not otherwise specified by the person I'd be in a relationship with.
So if the person was in a car accident and didn't have a living will, and you were the significant other, but not married, your voice wouldn't really be heard, right?
Right. And we've heard some of those cases in the media where there was a person wanting and needing to make that decision. What's very interesting is that a probate judge in Minnesota recently determined that in a probate case, he would honor the marriage of a same-sex couple from a different state. In other words, consider that marriage valid in Minnesota's, for Minnesota's laws, and for the purpose of Minnesota's laws. And then in that probate case, the inheritance was allowed to be had by the significant other, even though they weren't married in Minnesota. The marriage was honored as if it would have happened in Minnesota. So this will be an evolving situation, and the marriage amendment only means that we're not going to be having same-sex marriage in Minnesota per the Constitution if this is passed. Now, in 30 other states, they've passed this constitutional amendment. So odds are it could be passed here, but there's a strong effort opposing that at this time.
And we're taping, I should say, on September 17th. So
Right.
we still have a few weeks to go before all the arguments come out. But it's interesting hearing from a lawyer in terms of some of the things one would lose out on if they didn't have a legal arrangement. There is something now that you said is very new and not used much called the cohabitation contract.
Right.
Just in a sentence, what is that, Charles?
It's hard to put into one sentence, but a contract that's for cohabitation could address almost any and everything. Now, it can't give you protections under the law that the law doesn't otherwise give you in most cases. But what people can do is create any number of contractual arrangements, just like a business contract. And if someone breaches that, then you wouldn't be in family court, you'd be in district court bringing a litigation case so that people can decide if we lose our house, but we can't be married under the law, not just lose our house, but if something happens or one of us is going to leave the house, what happens to the equity in that house? If both people have invested in it, what do we do with the equity? Rather than start a lawsuit fresh, at least they'd have a contract to go on, but not many people are opting for that option either. Not many people are aware they can do that sort of thing.
Right, it's not something I've read about at all. We just have a couple minutes left. What about grandparents' rights in a divorce case? They don't have many, do they?
Grandparents do have what are called derivative rights. That means they derive their right from their child. So if the child's rights have been terminated as a parent, which is more common than you'd think, or if for whatever other reason the parent and child have become disassociated due to death, for example, then the rights disappear. So if you have a son or daughter who has been deceased, you don't any longer have rights to visit that grandchild, which I think makes no sense. But because it's a derivative right, you have to have the living child with parental rights. Then you have your own attorney. You can't and should not use the attorney that your child is using for their divorce. And you can bring what's called a motion before the court, in other words, a formal written request, requesting grandparent visitation. And there is a right to have grandparent visitation. Now, one of the parents may protest and say, this grandparent shouldn't have visitation, and the courts will give all faith and credit, or they'll give some credit to what that person has to say who is trying to prevent grandparenting time.
But the grandparent does have the right to bring the formal request. That's
Right.
good to know.
And very uncommon, but it does happen.
Well, we are out of time. This has
my
gone
gosh.
fast. And I've learned a lot, Charles. I think it's such a complex field as I hear and talk with you and think about it. Brings back
There's
a
a
lot
lot
of
to it.
lot of memories. If you would like to learn more about the kinds of things that go into divorce decisions and learn more about Charles Goldstein, his website is www.goldsteinlawyers.net.
Thank you very much, Mary.
Well, thank you
What a
for
pleasure.
coming down. As I said, I've learned a lot, and I'm sure the viewers have too. So I will see you in a couple of years. We'll have another
sounds good.
topic, I bet, to
Anytime.
learn about.
Sounds good.
Thank you for being with us. We'll be back again next week. Until then, have a good week.